Let's begin with our next session now, which is on 3D printing and intellectual property. I would like to call on the dais all the panelists, please. Mr. Prasanit Chaturpadhyay, partner, Lakshmikumaran and Sridharan Attorneys. Ms. Renu Bala, associate partner, SS Rana and Company, and Ms. Prachi Agarwal, partner Anand Anand. Let's embark on a journey to explore the convergence of 3D printing and intellectual property with our esteemed panel.
Okay, I'd like to thank the organizers, GIPC, especially Dr. Prachi Agarwal, for giving us this opportunity to talk on 3D printing. I'll be moderating the session, and depending on the time, I will be talking about 3D printing of tissues and organs. It all depends on the time. I don't want to keep you all because we have dinner after that. I have two speakers today. So we have Renu Bala from SS Rana. She's an associate partner at SS Rana. She does a lot of patent work, and she will be talking today on 3D printing and IPR, but with a patents perspective. And I have Prachi, who is from Anand Anand. She's a partner, and she mainly does a lot of litigation in all areas. So how we are going to cover this is, Renu is going to talk about patenting in 3D printing, and Prachi is going to talk about copyright and maybe a little on trademark. And when time permits, I'm going to talk about 3D printing of organs and what are the challenges in 3D printing of organs or tissues in the life science areas. I don't want to take too much time. Renu Bala, you can make. We'll give you 15 minutes and you can conclude by that. So you can plan your thing accordingly. You want to go there?
Good evening, everyone. So I'll start with the 3D printing technology. So basically what 3D printing is like, you have heard of a process of joining material layer by layer to make a 3D object. So it has been now over more than 10 years in 3D printing. So I just give you a brief glimpse of what 3D printing means. It's a process of joining materials to make objects from 3D model data, usually layer upon layer. So basically you give a command to a printer and then print, and you have an image fed to the laser printer or any printer, 3D printer, and it will give you a physical object. So now, so why a 3D printing? Like, what is the advantage of 3D printing? First of all, if you are a manufacturer and you want to manufacture a prototype, so it is very faster. You can just manufacture your 3D model and its prototype very faster. Second is sustainability, because it is 3D printing actually is additive manufacturing. So there are two types of manufacturing. What we know by today is that there is a subtracted manufacturing also. What subtractive means that you have a material, you are subtracting, you are taking out from it, and then you're manufacturing a part. Whereas additive manufacturing is layered, that you are creating any object from elemental level to a complete physical object. So there is there's zero waste. So you don't have waste material arising out of that additive manufacturing. So consistencies, you'll get a very high quality product with very good consistency, because it is being printed through a machine. Now, Charles Chuck was the first patent that was filed was by Charles Chuck, and his company 3D System Corporation, they released a first 3D printer called as SLA1 machine, and then he was called a godfather of 3D printing because he filed more than 60 patents around 3D printing technology. So there are many types of 3D printing that are available. First is, for example, so it depends on what type of materials you are using. and what type of printer you are using, and what is the end product you want. So you want a high quality product, you want a rough surface. There are many materials and products that requires different type of manufacturing. There are starting materials which require a different type of processing. So depending upon the process you want, there are different type of 3D printing. The most famous of it is stereolithography, that uses resin material, and it has every printer has a build platform, and then the source, how it is being cured. So for example, stereolithography, there is a light source to cure resin material, and then it forms it layer by layer. Then there is a laser that is used to cure thermoplastic polymer powder. So then there are fused deposition modeling. The most common of you must have seen filaments, plastic filaments, like it melts those filaments and then form layer by layer into a plastic object like toys. You must have seen 3D printed toys. They are mostly made up of FDM. Like you can see Elegoo Neptune 3 Pro FDM printer printing this toy. Then there is binder jetting. So there is a powder material we we add a binder to it like an adhesive, and then we create a full complete object. So what 3D printer requires is of course a printer, and then second is the material, and then there is a software that is required to give command to the 3D printer, then only it will work. So there are many softwares available in the market like Meta Control, Tinkercad, Blender. So these all are software which actually gives control and command the 3D printer to print that particular physical object. So how a 3D model is actually, first it is created as a 3D CAD drawing, and then because you cannot print anything from the CAD model, you have to convert into an STL file or a mesh type structure which can be understandable by that particular 3D printer. So in that language he'll take command, and then he'll print an object through the 3D printer. So we'll get the physical model after you get 3D, you have 3D command, you give 3D command to the printer. So 3D printing technology has actually grown very rapidly over past few years. Over a decade, its patents has increased a lot. So you find, if you can see, where high quality materials are required, like in aerospace technology, aerospace industry, automotive industry. You can see here there is a bus called Olai, is a driverless electrical recyclable bus. It can be printed. Even you can see whole buildings can be printed through 3D printer. For example, so you will find its application in food industry to make food items, healthcare and medical industry to make transplants, prosthetics. That is very prosthetics has a very vast applicability of 3D printing technology. And then there is a fabric and fashion industry. You must have seen these type of very intricate designs of 3D printed dresses. And then you can see here on left hand side the Apis core printed house in Russia and Canal House in Amsterdam. So these are, even you can print the 3D printed circuits or the motherboard from that. So and then you must have heard of the 3D printing toys like Hasbro and Formlabs. Hasbro is a toy manufacturing company, and Formlabs is a 3D printer who owns 3D printers, and it is very famous company for 3D printers. And they Hasbro, you can give command to for manufacture of toys, and you can make a selfie type of figurines of yourself through 3D printing. And Hasbro also lets fans 3D print toys like My Little Pony. So these are very very much famous toys. Then there is a website. So how 3D printing in manufacturing industry is that, so there is a Thingiverse 3D printing service. So what Thingiverse is actually, it provides a platform to the designers to upload their 3D designs, and it has a lot of over 2 million designs, and anybody can download these designs, modify it, then give an order to print that, and some 3D company who actually can take a print out of it, and you can deliver it to your to your house. So that's how 3D printing has become very famous. So 3D, how it is linked to IPR. So in 3D printing, it is linked to copyright, design, patents, and trademark. So copyright, all the artistic work, 3D images, source code, or object code of a computer program, they are protectable under copyright. Under design, 2D or 3D features of shape configuration that are actually applicable to the material object physically, which are physically perceivable to the eye, can be protected under design act. And patents actually protect functionality of the product. So if it is functional, it is technically advanced, it is inventive and novel, then you can protect it under Patents Act. Then trademark. So basically, trademarks, character serving as either a company's logo or its brand name or shape of goods capable of being represented graphically. The combination of colors, for instance, that actually distinguish a particular trader from the other, can be trademarked also. So talking about patents, so patents basically, you can protect an invention in the form of product, in the form of process, method, or composition. But provided it has to be novel, it has to be non-obvious, and it should have industrial applicability. So, it gives exclusive rights to the patent holder, if you have, to prevent others from making, using, manufacturing, or marketing the invention without consent of the patent holder. So there are many conditions of non-patentability. Okay. There are many conditions of non-patentability, so you have to look into that. And there are some examples of 3D printing. For example, tooth enamel, you can see. There are transplants, you can see. There are different type of polymerizable polymers, you can see. So 3D printing technology, you can see very well from this European patent report that number of patents have increased a lot from last 10 years. So you can see that US is the most, here it has filed the most of the patents, then followed by Japan and Germany, and then other countries follow. So here is top 20 3D patent applicants in 3D printing technology. So basically, there are two things about patents and designs. Like you cannot, so private non-commercial use is not infringement, but if it is used commercially, then it amounts to infringement. Regarding software per se program, if it is a software per se, it cannot be patented. That is a limitation of 3D printing technology, that you are developing a software, you cannot protect it, and then that is why you cannot enforce it. Regarding design, as I told, that it gives features of shape configuration if industrially applied to an article, and the finished article has to appeal to your eye. So it has to be original, and it has to fulfill all the condition of patentability, and it should not be anything just non-functional features. It has to, you can protect only non-functional feature through design and functional feature through Patent Act. So there are few examples of designs you can. All right, so thank you.
Thank you. Thank you. I know today this is the last session, and I don't want to keep everybody. We have been given time limit by the organizers. I now call Prachi. If you can talk on copyright. You want to stand there or talk later?
Good evening, everyone.
Introduction of yourself.
Yes, good evening everyone. I'm Prachi Agarwal. I'm a partner at Anand Anand, and I'm predominantly doing IP litigation and mostly Delhi High Court. So we are talking about 3D printing, and I want to touch upon the aspect of copyright and a little bit about trademark. Before I actually go into the aspect of copyright, first of all, there are two aspects you're looking at. One is the protection of products and processes which are being created by 3D printing. That is one aspect, and Ms. Bala has already referred to in briefly how it can be protected under different IP, and she has elaborated on designs and patents. The other aspect is that 3D printing itself is being a threat to existing IP rights, because there's ease of replication, ease of downloading, and a lot of times it's difficult to trace these kind of activities. So first I'm going to talk about how 3D printing products and processes can be subject matter of copyright. As already explained in detail, the process of 3D printing basically starts with this computer-aided design file, which is a CAD file. Now this CAD file comprises, it can be created in two ways. One, it could be a software with detailed set of instructions and code as to how an object has to be created, which means what materials have to be used, how those layers have to be printed, and finally including the shape, configuration, everything. And then finally, once those instructions are sent to the printer, a final object is created. Now, in this particular case, if you look at the Indian Copyright Act, under Section 2 of the Copyright Act, you have literary work, and it comprises of computer program. So which means that if this particular software or this code of instructions, it definitely falls under the purview of a literary work under the Copyright Act, in not just India, in other jurisdictions as well. Obviously, you have to satisfy the requirement of originality and all of those other things, which is a prerequisite of a copyright. Now, the other aspect where you're simply scanning an object and creating this CAD file, because this is another way, like I take a physical product, for instance, I take this pen, and I scan it and I create a file, and thereafter a 3D printer is given instructions and it's printed. Now, in this case, there may be an issue of originality in the CAD file, which may not give it copyright protection. In fact, it could also be an infringement if I have an IP in this particular object. So these are the two ways in the copyright scenario when you're talking about the CAD file. Now, in addition to this CAD file, you also have the final printed object which is being created. And obviously, even that can qualify as for instance, as an artistic work under the Copyright Act. It can also qualify under the design. It can be a design under the Designs Act. So these are the different aspects. There's also one more conflict. Like when you're talking about these CAD files, a lot of jurisdictions have stated that it could not only be literary work, it could also be artistic work, because it's like a digital blueprint or a design of a product. So to that extent, it falls under the definition of artistic work under the Act, which is defined under Section 2C of the Copyright Act. And this has been a situation in other jurisdictions as well. In fact, interestingly, one of the first cases of copyright in 3D printing was this case involving the Penrose Triangle, which was something in US in 2010. An artist created a 3D version of an existing optical illusion, which was there for quite some time. And that particular 3D version was copied by someone else. So there was a notice which was sent of copyright infringement. Of course, the matter was settled, and it didn't really go into those details of ownership or liability, and the fact that when you are creating a 3D version of an existing work, whether not just the fact that you may not get a right on it, you might also be infringing that particular work which is existing and which has an IP. So these are the different issues which are involved. And obviously you have to have originality in these works, and you also have to make sure that you are meeting the standards of, for example, doctrine of merger, which can be an issue in case of a software. So this is like the subject matter of copyright. Now what happens, what are the challenges that we are facing in the IP fraternity when it comes to infringement by 3D printing? So for example, I gave an example of this pen. Now this pen could be a subject matter of copyright for its aesthetic appearance. It could be a subject matter of design, again for its aesthetic appearance. It could be a subject matter of a patent if it's the functional and the technical part of it. In all of these cases, if I am scanning this particular product and I'm making a simply 3D version of it, it will, under the traditional IP laws, it will amount to infringement. Obviously, you have to say, it will depend on case by case basis, because A, you have to see whether the underlying work, the object which is being scanned or copied, whether that is protected by IP, what protection is there, and second, you also have to figure out liability, because another challenge which is faced in case of infringement, like I already mentioned, a lot of times it's difficult to trace these infringement. The second aspect is a lot of people are doing it for, there are a lot of these hobbies who are doing it for creative purposes. They are not actually commercializing. So sometimes there could be exceptions of fair use or fair dealing. And the third aspect is when you are printing purely functional part of a copyrighted work. So if you look at section 52(1)(w) of the Copyright Act, if for instance, I'm only printing, like say the cap, which has a function, and this entire pen could be a subject matter of copyright, but I'm only printing which is something functional and not the aesthetic part, then I cannot claim copyright infringement. I might be able to claim patent infringement if it's a subject matter of patent, but those are the exceptions in case of copyright. And of course, the traditional exceptions, like if a small portion has been copied, which is again one aspect of 3D printing, because a lot of times it's decentralized and people are only doing it as a DIY projects, for instance, at home. So they, like I said, they may not be commercializing, or they may not be making, or rather producing the products at a very large scale, or maybe only a non-substantial part of the product is copied. So these are the various challenges, and as solution, I would say, like even in the previous session, they spoke about NFTs, and there was an emphasis of, having a contract in place, having licenses in place, because at the end of the day, 3D printing as a technology is definitely very beneficial. And as my co-panelists already spoke about the application of 3D printing in various technology, you can print drugs today, you can print organs today, and then in aeronautical space, in aerospace, all of these, and you can collaborate. It's very easy to do, it's less expensive, you can customize. So the benefits are definitely plenty. So we just have to make sure that, in order for it to actually be completely beneficial and not be a threat to existing rights, I think we need to have licenses and contracts in place. And a lot of these platforms like Thingiverse, which actually have these CAD files available for download and for printing, they do take licenses from different individuals who are owning rights in the underlying work. So, I mean, that would be my take on this. As regards, there's a fun fact recently in August 23. In fact, a post office has been created by 3D printing in India, in Bangalore. So I think that's where we are heading. An entire post office has been printed, and we have seen that buildings are also being printed. So this technology is definitely beneficial. Quickly talking about the trademark aspect, I didn't find it as complicated, because if you look at section 2 of the Trademarks Act, a mark also includes a shape mark. So one way of protecting your trademark through 3D printing is that you could register whether, like for instance, you have so many shape marks now. Zippo lighter is one example. So you can actually register more shape marks so that anyone who's trying to replicate it, you could even have an action under the Trademarks Act. And even if you don't register, sometimes you can have an action under passing off. So these are the things. And quickly, another small point, I'm not going to deliberate too much on it because it's something which is common to all kinds of IP violation, is what is the liability of these platforms who are actually providing, I mean, they could even qualify as an intermediary, they could even qualify as actually liable, or they could say that we are not using for commercial purpose because we are providing these softwares free for download. So those are again liability issues, I think, which kind of pose as a challenge in case of infringement.
Yeah, is that okay? So what I'm going to do is, I think Renu talked well about her, how 3D printing is actually done, and Prachi talked about the copyright issues and a little trademark issues, but mainly a lot of copyright issues. What I want to delve in the next 5 minutes is about 3D printing in life science sector, which is actually like tissues and organs. Now, we've seen with both of them speak that 3D printing in mechanical, medical devices, engines, aerospace, they're very good. Wherever you have intricate, even if you have an intricate jewelry design, it becomes very easy. But what are the patenting challenges that we have when we 3D print a tissue or 3D print an organ? And these are happening today. Because today, if I want to get an organ, I have to wait a long time, and nobody's going to give me the organ. Somebody has to be brain dead before I can collect their organs to do that. So there are different types that we can do. So if I do need a liver, because of liver cirrhosis, my liver is gone and I want to have a liver, I may not get it very quickly, and therefore I could 3D print it. But what is the issue that we are having as far as patenting? I'm not talking too much about the technology, but I'm talking about the patenting challenges of 3D printing a liver or a tissue in the patent challenges that we have. So one of it is discovery versus invention. Of course, it's very easy. I will say, oh, you can patent, you can 3D print a liver, you need a scaffold. The scaffold it could be a hydrogel, it could be a polymer, and based on that, I could make my liver cells. Just, you keep layer over layer, you add the cells. The cells could have been grown in a fermenter. It could be human cells. It could be my own cells. If I want a liver, I can take my own cells and produce these liver organs. So the question is discovery. Because I am using human cells, a liver is already there, and I'm creating another liver. And therefore, it will be considered as discovery. And in India, you have section 3C that naturally occurring material or products cannot be patented, like DNA, RNA, protein, cells, naturally occurring. So you can have genetically modified. And also the liver exists, and you cannot go and say, I can get a patent for a product. Yes, method of producing a liver is patentable, no problem, because it's a 3D printing, I have to have special cells. So then the problem is really what cells are you using? If I'm using my own cells, I do have again a problem. You've seen in the Myriad case, you've seen in the Mayo case in the US, that naturally occurring products cannot be, like DNA and RNA cannot be patented. We've seen that in the BRCA1, BRCA2 story. We've also seen it in the Rosalind story of Dolly the sheep, where you created an exactly same Dolly, exactly same sheep like the mother. So you're creating, the method of producing Dolly will be patentable, but Dolly the sheep will not be patentable. So I come back to liver. So first and foremost is we need to understand, is it a discovery, is it an invention? So if you're going to use the same human cells to make this liver, it will not be patentable. Under discovery versus invention, it may be patentable in Europe, but not in US and not in India. The second thing is, the scaffold, I might say, oh, my liver doesn't have a scaffold, but finally when I make the liver organ, I'm going to remove the scaffold. The scaffold is only like a base. And if I do come up with a liver along with a fibroblast, now why would I add a liver cell with a fibroblast? So one is, I would take my liver cells, I make stem cells, and I can convert them to liver cells by placing them on the liver, and then also it will come under naturally occurring material or cells and not patentable under discovery. But now I make a liver organ by using a liver cell and a fibroblast. And I don't have a liver containing liver cells and fibroblasts. The reason I put fibroblasts is it will start proliferating very quickly. So what I do is I make a layer of liver cells, not the exact organ. I place it on my liver, it will proliferate and I will get more liver, right? But I cannot donate my own liver, but I can get my cells to do that. So the minute I make an organ having a liver and a fibroblast cells, then it is not discovery, because nobody has a liver with a liver cell and a fibroblast. Second, I take a liver cell, I'm deficient in some enzyme, and I make a genetically modified liver cell, and then I can make a liver organ using 3D printing. Even then I can get, because I don't have genetically modified cells, do not come under discovery. So you need to look at this thing, and there's also some ethical aspects, just like Dolly the sheep, you got ethical aspects, there may be. But then to get a liver, a donor to give me a liver, which has also to match my cells for a lot of the markers, may be difficult. So there is a lot of future in 3D printing of tissues and organs, but the challenges is in patenting. So one of the things, as I already mentioned, is the discovery versus invention. But we also have other issues. What are the other issues? If my liver is not same, but I have fibroblasts, I also have regulatory issues, because people might say, that you can't allow and all that. I also want to take up I also need to take up that we need extracellular matrix. So it's just quite a task to do that. So to exactly produce that without blood vessels and so on. So these are developing area, but we do have a lot of challenges when it comes to patenting, mainly on discovery versus invention. But also there are areas like a cornea. A cornea doesn't have blood vessels. And I don't have to use anything else to get a cornea organ, to get a person to donate their cornea. There are a lot of people in India who are actually blind because they don't have a cornea, and they need a cornea, somebody to donate them. But you can 3D print a cornea, and you can use synthetic material polymers, and that's one organ that does not have blood vessels. So people have to think about it, and people are thinking about it, that which are the areas in the life science area that you can do 3D printing. In medical devices, in a lot of things you can do. Now the other area is, like she just said, about knee implants, hip implants, or I've had an accident and I want to have a prosthetic. You can actually do 3D printing exactly like mine. So if I've lost a limb or I've lost a bone in one leg, I have to actually go do an X-ray, do an MRI of my other leg, create a CAD file, and I can actually produce that. So actually 3D printing does have in things which do not have any human cells. But the challenge in patenting is when there are human cells, how do you actually patent this? We've also seen there are certain changes. If I make, like we've seen in the Ariosa case versus Sequenom, or in the Myriad case, you make small changes, it becomes patentable. Like cDNA is patentable, but DNA and RNA are not patentable because they're naturally occurring things. Now, I have this case where there is a fetal DNA. The fetal DNA is exactly like what the other fetal DNAs are human, so those don't become patentable because they are naturally occurring material. So the challenges in 3D printing of organs and tissues are that it has to be similar to me, similar to the humans, but once it is similar to the humans, you have discovery issues. If it is not similar, then you have regulatory issues. But it's an upcoming area. We don't need donors for several things like liver, certain kidneys, or even certain other organs like the cornea and so on, which can be 3D printed. So I think there's a huge market, and don't wait for donors. So, but the challenges are in patenting. Thank you everyone for listening. If there are any questions, we could take 1 or 2 questions. Thank you.
Okay, so let's conclude now. I would like to extend my sincere thanks to our knowledgeable panelists for their invaluable contribution and dedication to excellence. I'm sure that the ideas exchanged here will be the seeds for future innovation and success. I would request Ms. Naintara Sanyal, partner ALMT and Legal, to please present memento to our panelists.
Thanks everyone.
Thank you, everyone.